In discussions with our clients and developing an estate plan for them, the bulk of our clients, a lot of their wealth is in tax qualified accounts. By tax qualified accounts, they've generally worked someplace and had a 401k, and now that they're retired, those funds have rolled over into an IRA. So the bulk of what they own is in tax qualified accounts. What they might not understand is the tax ramifications of leaving those to particular individuals after they've passed away. They used to have much different rules about tax consequences for those tax qualified accounts before the Secure Act was passed. When the Secure Act was passed, once an individual passes away and leaves an inherited IRA to children, they have to take those distributions out within 10 years. So if you're leaving $1 million to your child in an inherited IRA, at minimum, they're going to have to take out $100,000 extra in income every single year. Now, there are specific changes that you can make to your estate plan to see what you can do in order to protect those tax consequences. For instance, if you have a child with a disability and they receive an inherited IRA, they can stretch out those distributions over the course of their lifetime. So in that same scenario where a child would have to take $1 million out in 10 years, taking $100,000 out a year, and you have a child who's 35 with a life expectancy of 40 years, they could spread that $1 million out over the course of 40 years as opposed to 10, which would greatly limit the tax consequences of an inheritance.